reasonable limits, and then adopted an amendment right under that one in the duties section still that says, in relation to that paragraph I just read about protecting the right, the government has a duty to uphold principles such as principles of environmental justice, the principle of non-regression, and the principle of intergenerational equity. So now we come to section 44, which is about research studies and monitoring activities to support the government in protecting that right. And we know now that the right includes those principles. So adding research studies and monitoring to protect the right and apply the principles is sort of disconnects the principles from the right. Like you could say it's already included in saying that it's protecting the right. I hope that helps.
So the amendment I'm looking at here is about defining these so that they're clearly understood by anybody interpreting the act going forward. And by clearly defining these, we're disconnecting it somehow because these aren't previously defined in the legislation, unless I'm mistaken.
Okay, so I thought we were on PV 10.
We are. Yeah.
So I think PV 10 says section 44 of the act is amended, and under section 44 is subsection 3.1 that says the minister shall conduct research, studies, or monitoring activities to support the government of Canada in protecting the right to a healthy environment, referred to in paragraph 2(1)(a)(2), and then adds and
my mistake. My apologies.
Paragraph.
Sorry, only because I'm now hoping to make sure that we're all on the same page. So we're currently on version 3 of the amendments package, page 40. Green amendment or PV 10 put forward by Madam May. Yeah. Okay, and okay, just to make sure we're clear.
Any more comments or questions? No. So I guess we can go to a vote, Mr. Clerk.
Mr. Dogood.
Opposed, Mr. Chair.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson. Mr. Weiler.
Opposed.
Mr. Deltel. I'm sorry, could you repeat?
Yes, sure. Oppose.
Mr. Kirk.
Opposed.
Mr. McLean.
In favor.
Mr. Lake.
Opposed.
Madame Posey.
En faveur.
Ms. Collins.
In favor.
And Ms. Thompson. Ms. Thompson?
My apologies, opposed.
Yeas pour 3, nays contre 8, 8.
Okay, donc l'amendement est défait.
The amendment is defeated. So that brings us to G8. Is that correct? Who would like to present G8? Mr. Weiler.
Understanding is that given that they substantially are the same, that given that the PV10 was rejected, that by the same token, G8 wouldn't be movable.
So you don't want to move it? Okay. So
Mr. Chair?
Yes.
Just as a point, I think it is movable, but it may be unwinnable. But I do thank Mr. Weiler for trying it.
Okay. Thank you. Shall clause 7 carry? Mr. Clerk?
So, Mr. Dogood.
Support.
Mr. Longfield.
Support.
Ms. Taylor-Roy.
Support.
Ms. Thompson.
Support.
Mr. Weiler.
In favor.
Mr. Deltel.
En accord.
Mr. Kirk.
In support.
Mr. McLean.
In favor.
Mr. Lake.
Oui.
Madame Posé.
Pour.
Ms. Collins.
In favor.
Yeas pour, 11, 11.
Okay, so clause 7 carries. Shall clause 8 carry? Does anyone want to speak? Yeah, shall clause 8 carry? There's no amendment, sorry. So we'll go to the vote. On division? That's good? On division? Okay, it carries on division. Clause 9, we have CPC 3. Who would like to present that amendment? Mr. Coury?
Sorry, Chair, just getting...
No, take your time, and up to a point, of course.
So point of order, Mr. Chair, because of I'm the one that sent the amendments to the clerk. So this amendment was written by Mr. McLean. Is Mr. McLean able to move it, or am I the one that has to move it? Okay.
I'll move the motion. So withdrawal of K2, lines 10 and line 11, hydraulic fracturing and tailings ponds. These are additions to the Act that are currently covered under provincial legislation as far as the monitoring of environmental activity that's associated with one specific industry. And as far as tailings ponds go, one specific province, much of which have been ameliorated over the last decade. So I think involving the federal government in an overlapping jurisdictional regulation here is adding more bureaucracy into the environmental oversight of one industry in particular, and I think it's something that might be opposed from provincial governments across the country if it's put forward this way, and I suggest that we withdraw it at this point in time, sure that it is something that's clearly done and regulated at the provincial level where it is done very effectively currently.
Anyone have anything to add? Ms. Collins?
Well, I would definitely disagree that tailing ponds are predominantly remediated and that these kind of issues are being dealt with effectively. And yeah, it definitely doesn't only have to do with one province. There are tailing ponds in mines across the country. And this is an ongoing issue. I think it would be a tragedy to delete these two lines. So I hope we don't.
Anyone else? Mr. Longfield.
Thanks. I'm just rebooting my computer to see my notes, but as I recall, this falls all. Tailings ponds are not excluded from the existing legislation, so it's already covered in the legislation. So I'd support taking them out just as a matter of redundancy.
Weiler?
Yeah, I would agree with Mr. Longfield here. Clearly, hydraulic fracturing and other activities that cause tailing ponds are activities that are covered under K1, which are activities that may cause or that may contribute to pollution. So by removing this, it is a redundancy that we're removing, but certainly we should be concerned about the potential for those activities to cause pollution to the environment and to human health.
Ms. Taylor-Roy?
Yes, I agree. I'm quite concerned about these activities as well, but as Mr. McLean has said, it's in provincial legislation, but I don't think that not specifying them here actually prohibits us from the government from looking into that, because if they are causing pollution, they will be included in there. So, I mean, I understand what you're saying about the provincial federal jurisdiction, but I don't agree that the federal government shouldn't have any role, but I don't think it's necessary to spell them out here.
Yes, Ms. Collins.
I guess I'm a bit confused about if this is something that the legislation is covering, why people would be opposed to specifically naming an instance of environmental pollution that we need to address. So it's surprising to hear my colleagues across the way in support of removing something where we should be addressing this issue and we should be addressing it and naming it.
Anyone else? Ms. Taylor-Roy?
Yeah, just to respond to that, I think that these are the issues we're talking about right now, these two specific ones, but given that this legislation hasn't been updated for decades, and that this is likely to stand for a while, I think trying to name things, all these things in the actual legislation is problematic because these things will change over time, and there's going to be other things that come up. And if we list things and it's not exhaustive, it's kind of like, well, it's issues that are important right now, but that may change over time. Perhaps these won't be an issue down the road. So I just don't know that we have to put details like this into this legislation when we have the regulations and we have the framework coming up as well.
Ms. Collins.
I love my colleagues' optimism that we're going to address these issues quickly, and the government has repeatedly said that they are going to be bringing back this legislation for further updates. So I hope they are genuine in that those statements. And if that is the case, putting in explicit mention of environmental pollution, an instance of environmental pollution, and in particular tailings ponds, that we do need to address now, shouldn't be a problem, given that the government has promised to bring this legislation back to keep updating it.
Okay, I don't see any other requests to comment. Or shall CPC 3 carry?
Mr. Dogood.
Oui.
Mr. Longfield. Ms. Taylor-Roy.
Oui.
Ms. Thompson.
Approve.
I'm sorry, was that in favor?
In favor.
Thank you. Mr. Weiler.
Yes.
Mr. Deltel.
Pour.
Mr. Kirk.
In favor.
Mr. McLean.
In favor.
Mr. Lake.
Yes.
Madame Posey.
Pour.
Ms. Collins.
Opposed.
Yeas pour 10-10, nays contre 1-1.
CPC 3 is carried. Shall clause 9 carry as amended? On division? Okay. Which brings us to clause 10 and PV 11, which is deemed already moved. And I'll just mention that if PV 11 is adopted, NDP 12 and NDP 13 cannot be moved because of a line conflict. Ms. May.
Thank you, Chair. And I know that given the strictures of the motion that compels me to be here if I wish to make amendments, which would otherwise be my right at report stage, I have to be brief. This is particularly challenging with this amendment because it is 5 pages of content that is intended to replace what we find now under S-5 running from, basically Section 10 and what would be in the new version of SEPA, Sections 56(1) right through to the beginning of the next subsection. The goal here, rather than try to walk you through the amendment, for which I obviously won't have time, I'll at least explain the rationale. The Canadian Environment Protection Act has had a discretionary approach and to the creation of pollution prevention plans. There's basically 2 strategies under the Act. You can have a pollution prevention plan or you can have a pollution abatement approach. If you're going to eliminate toxic substances, particularly those that are carcinogenic, that are mutagenic, that are seriously a threat to human health, bearing in mind that this Act is both environment and human health, and that both ministers play a role, Minister of Environment, Minister of Health, even though we're before the Environment Committee. These are seriously dangerous chemicals for human health, and yet of the 19 substances that were listed as eligible for this kind of pollution prevention plan, so far in the experience we've had since 2000, only 25 substances out of 150 had a pollution prevention plan created.
So this amendment then it requires, could you just explain what the amendment?
Yeah, the purpose of the amendment is to ensure that those chemicals that are significantly a threat to human health have a mandatory requirement on the manufacturer to move away from them. There are sections here that allow us to consider that there's an economic problem with moving to elimination, but in brief, and it is hard to do this in brief, this would make pollution prevention plans mandatory for all Schedule I toxic substances. It's about eliminating the creation and use of toxic substances.
Okay, well, that was very clear and succinct.
Thank you.
Go ahead, Mr. Duguid.
Thank you, Mr. Chair. I just wonder if we could hear from officials on this. I know the folks from SELA had brought this up a number of times.
Who would like to address
wouldn't
this?
mind hearing their perspective.
Mr. Moffet? You're on mute, Mr. Moffet.
Is that better? Can you hear me now? Sorry.
Yes, we can, yes.
Okay, my apologies. I don't think that we have any objections to the stated goal of promoting pollution prevention in that the Act itself already requires ministers to give priority to pollution prevention when risk managing substances. The challenge with this amendment is that it would require the government to require pollution prevention plans with respect to every listed substance. In fact, pollution prevention planning is only one way to promote pollution prevention. It's a bit unfortunate that the term pollution prevention planning has become confused with the overall concept of pollution prevention. When we assess a substance as toxic and needing risk management, SEPA gives us access to a wide range of risk management instruments, including the authority to require plans, but it also, of course, authorizes us to regulate, including to prohibit the use of a substance, which is the most effective and powerful way to achieve pollution prevention. It ensures that the substance is not used and therefore never enters the environment. So by requiring the ministers to use this one tool for every substance, it in fact would be an unnecessary imposition when in fact other more stringent and more immediately effective measures can and have been used to achieve the overarching goal of pollution prevention.
Thank you. Would anyone else?
May I respond?
Very, very, very briefly, please.
I'm sure inadvertently Mr. Moffat has mischaracterized this amendment as requiring a pollution prevention plan for every substance. As I mentioned, if you look to subsection 13 at page 47 of your amendment package, the applicant may have the opportunity to convince the minister that socioeconomic benefits of an activity outweigh the risk and the analysis of alternatives. There are ways to continue to deal with each substance. It isn't a flat prohibition, but it does give the minister tools that currently are not found in this Act, and the duty to regulate where substances are extremely dangerous.
Thank you. Ms. Collins?
I was going to say the same thing. I read through the amendment and I saw a clear path to the minister not doing this if it was shown as Ms. May has just explained.
Excuse me, anyone else? Okay, we can go to the vote on the amendment.
Mr. Duguid.
Opposed.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Oppose.
Mr. Weiler.
Opposed.
Monsieur Deltel.
Oppose.
Mr. Kirk.
Opposed.
Mr. McLean.
Opposed.
Mr. Lake.
Opposed.
Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas pour 2-2, nays contre 9-9.
Alors, l'amendement est défait et
The amendment is defeated, which brings us to NDP 12.
Since it
OK.
would-
Alors, l'amendement ne se...
The amendment will not be presented. Mr. Chair, yes, Ms. Posey. Given that that amendment is not being presented, I have one that the clerk has that I'd like to table now on the fly. And what it says, the interpreter doesn't have the text. It's that in Article 10 at line 34 of page 7 of the Act, it says that if it believes, based on evidence, independent evidence, information provided by the requester, and that this is reasonable. What I mean here is that currently the industry justifies itself, and we know what has happened. I can give the example of Louis Robert in Quebec. The industry has too much influence on decision making. So if we have independent studies in addition to this, then there could be some balance. Well, what we're saying is that before we move to your amendment, we need to deal with the amendment NDP 13. Ms. Collins.
Mr. Chair, and I'm very interested in Madame Posey's amendment as well. But I chose not to move NDP 12 because it would conflict with NDP 13. And so the amendment itself really is to incorporate the principle of safer substitution into this Act. And if my colleagues will, if they haven't read through it thoroughly, definitely look at the section 1.1 that talks about more sustainable alternatives to the substance, using safer alternatives. I hope that I'll find the committee support for this.
Sorry, I forgot to mention that. So you can move it. Yeah. Who would like to speak to it? Well, Ms. Collins just presented it. Would anyone else like to speak to it? Madame Posey?
C'est juste. I don't understand one thing. The part that's in parentheses is very different in English compared to the French. One moment, please. C'est dans le NDP 13. This is in NDP 13:10. To answer Ms. Posey's question regarding the difference between English and French, is that what you're saying? Yes. Where? Under the 4th heading. Can you say what you said last time? Where's the difference? Where you see the 4 between brackets under substitutions, lines 28 to 35, then there's a 3, then there's point 4. I just think there's a chunk missing. When you see how long the English is compared to the French. Translation omitted 3 lines. I'm not a legal translator. I'm not involved in this, but just reading it at a glance, you can see that there's a big difference between English and French.
That period to have the extension.
C'est assez évident.
Yes, indeed, it is quite obvious that there's a difference.
Est-ce qu'il y a moyen de...
Is this something we can send back to them? Inaudible to the interpreter.
Alors, je pense que ça vaut la peine, mais on peut vérifier.
I think we can do this. Can we check in the meantime? The response is inaudible to the interpreter. What we're suggesting here is that there are already 2 amendments that have been set aside for the end. Perhaps we can add NDP 13 to this as well. Ms. Posey, correct me if I'm wrong, but you're saying that your amendment, the one that you would like to present, depends on the decision we make regarding NDP 13. Correct. So can we set NDP 13 aside? And Ms. Posey, your amendment will also be set aside for now as well. We'll move this to the end, and this will give us an opportunity to verify if there was just a simple mistake in the translation.
Just to clarify, if we're setting that aside, would we not set the whole section aside as we did?
Yeah. So basically, clause 10 is